I was just going to say, everybody who's here for all of the matters, you'll get to vote for who you like best as a hearing examiner.
The battle
Hope
of
it's
the
a secret
giants.
ballot.
Well, hello, everyone. My name is John Baza, and I am the designated hearing examiner for the Board of Oil, Gas, Mining in this proceeding, which I'll announce in just a minute. Today is Wednesday, February 18th, 2026. It is the time and place for the hearing examiner's proceeding for docket number 2025-049, cause number 132-81. This is in the matter of the request for agency action of U.S.M Energy Company for an order pooling interests, including the compulsory pooling of interests of certain non-consenting owners within a 1,920 acre or substantially equivalent drilling unit established for the production of oil, gas, and associated hydrocarbons from the Lower Green River-Wasatch, parentheses, Colton formations, comprised of sections 19, 30, and 31, Township 2 South, Range 1 West, U.S.M, Duchesne County, Utah. We're holding this hearing with an anchor position in the Department of Natural Resources building in Salt Lake City, Utah, and we are doing this as a recorded meeting, and we appreciate the help of all the staff who are present. Do we need to introduce people who are in the room? Is that something we usually do?
I don't think so.
Okay. Before we begin, let me ask, are there any members of the public or respondents present that are going to comment or participate in these proceedings? No one's raising their hand.
There are not any online either.
Okay. So let the record show no public or respondents were present today. So with that, let's start by taking appearances of counsel. First for the petitioner.
Thank you, Mr. Baza. Mitch Mayo of Lear & Lear PLLC on behalf of the petitioner, U.S.M Energy Company.
And I believe we have representation for the division.
Yes, Mr. Baza, my name is Nico Micheletti, Assistant Attorney General, representing the division today. With me are division experts Peter Pankey and Spencer Nish.
Okay. And I have counsel present for me this morning, Mr. Gary White, at the Attorney General's office. First of all, some housekeeping items I need to go over with you. I want you to know that I've received declarations in the last week from Mr. Levi Dean, I believe, and Mr. Brad Peterson in this matter, and I've reviewed those along with all of the exhibits that were filed in the matter. I do need to point out that there is some school and institutional trust lands acreage included in this drilling unit. Because of that, I need to declare that I have a position on the SITLA Board of Trustees. I'm a member of that board. So I need to ask, first of all, are there any objections to me serving as the hearing examiner in this matter? I believe all those matters, all those lands are leased, so.
Yeah, I mean, from SM's perspective, there's no issue. It won't impact the pooling, and we value and appreciate your expertise in this cause, so no objection.
No objection.
All right, thank you. Then I'll proceed as hearing examiner. Let me ask the division, have you reviewed the declarations? And are you okay with the filing of those?
Yes, sir.
Okay, appreciate that. Do we want to accept the declarants as being qualified as expert witnesses?
Well, I'm happy to go through that and get to that process, and maybe just jumping in.
We'll go ahead and proceed according to your plan at this point.
Okay. Well, that's a great lead-in, Mr. Baza. Thank you. With us today as witnesses in this matter are Mr. Levi Dean, if you could raise your hand, Levi, and Mr. Brad Peterson. Levi Dean is a senior landman at U.S.M Energy. It's his first time testifying before the board. He's going to do it several times today, so we should take our time and make sure we qualify him and like him as an expert before we approve him as such. Brad Peterson's been recognized as an expert by the board numerous times in reservoir engineering, so I just move that we accept him as an expert, again, for purposes of this cause. At this time, before we move any further, it's probably appropriate to ask that the witnesses be sworn in.
Okay. Do I do that or does someone else do that?
Do you need some language?
We used to have the court reporter do it, Patty, but I can get you some language. If you want.
Well, I think I can remember what to say. Okay. Would I have the two witnesses raise their
They're
hand?
on the very bottom.
All right, guys, we got language here. We're going to have you sworn in, so raise your hands and we'll get this.
Okay. Do you solemnly swear that the testimony you shall give in this matter shall be the truth, the whole truth, nothing but the truth, so help you God?
I do.
Yes.
Thank you.
Thank you. As mentioned, the witnesses have both filed written declarations outlining their testimony here today. The hope is that'll speed things up and make it a little easier for everyone to analyze the statutory and regulatory requirements and either grant or deny the request before you. Housekeeping note, this matter was filed way back in September of last year. Has been continued 3 times, twice to allow for kind of internal issues on our end, once to make sure that all these came at one hearing. And so we appreciate the divisions working with us and the hearing examiner's flexibility in accommodating the schedule moves. As Mr. Baza mentioned, petitioners filed declarations last week. Those are on file and we'll be able to, the witnesses are here today to answer any questions or go through anything you have concerning those declarations. As I mentioned, this is Mr. Dean's first appearance, so I will qualify him or attempt to as an expert in petroleum land management before we start with his testimony. Now would probably be appropriate. I'd like to move that we admit Mr. Peterson as an expert in petroleum engineering, reservoir engineering, again, for purposes of this cause, without objection from
No
the
objection.
No objection? Yeah, let's accept that.
Okay. The board and by designation, Mr. Baza as the hearing examiner have jurisdiction over this matter pursuant to Utah Code 40-6-6.5 and the implementing regulations. A copy of the request at issue and the notice of opportunity to participate was sent by certified mail to all the known parties to be compulsory pooled and regular mail to all other production interest owners within the what we'll sometimes call the Austin Other 1920 DSU. All of the addresses for the mailings, both the certified mailings of the notice of opportunity to participate and the mailings of the request in this cause were sent based on a search of the Duchesne County realty records relevant to the lands and of SM's internal records. Notice was also sent of the request to all relevant institutional parties, including the Trust Lands Administration, BLM, BIA, etc. These were mailed as outlined in paragraph 26 of Mr. Dean's declaration and as outlined in the certificate of service filed in this cause on September 15th. Also, there's additional evidence in the form of the return receipts filed as Exhibit 14 in this cause. Finally, notice of the filing of the request was also duly published following authorization by the board on September 11th in the Uinta Basin Standard on September 24th and October 1st, 2025. Exhibit 13 on file is a true and correct copy of this affidavit of publication. On February 10th, the Division of Oil, Gas, and Mining filed a responsive pleading expressing no opposition to the granting of the request pending the full examination of evidence here today. I'd like to note, pursuant to the order delegating this to a hearing examiner, there are no other objections or responses to the request that have been timely filed or that are pending as of today. Brief summary of the case. This cause involves the compulsory pooling of a 3-mile unit, a 1920-acre drilling unit established by board order entered in June of 2024 in cause number 130-31. I may refer to this as the current order. This unit was established for Lower Green River-Wasatch formation production, and this unit comprises the entirety of sections 19, 30, and 31 in Township 2 South, Range 1 West. Again, I may refer to this as the Austin Other Unit or the Austin Other 1920. In accordance with the current order on file in this cause as Exhibit 2, XCL, as SM's predecessor in interest, drilled, and SM now produces from the 3 Bigglesworth wells that were identified in the request. Those wells are the Bigglesworth 32-31-30-19-21B, which spud on May 6th, 2024, with a date of first production of January 7th, 2025. Second well is the Bigglesworth 52-31-30-19-21A, which spud on May 6th, 2024, with a first production date of January 7th. And the Bigglesworth 75-31-30-19-21E well, but on May 10th, 2024, with the first production date also of January 7th, 2025. I'd like to note a correction. I said January 7th a couple times there. In the request, there was a typo. I identified mistakenly the date of first production of the wells as June 7th, 2025, when in reality, the division records, the well completion reports, and the testimony from the witnesses makes it clear that it's January 7th, 2025. So I'd just like to clarify that for the record. That will be reflected in the order of the issues. There are 10 owners of undivided oil and gas interests in this unit and these wells. They were all listed on page 2 of the request as parties that were required to be compulsory pooled because they had failed or refused to voluntarily commit their interest to the unit. Although SM has had discussions with some of the owners of the interest to be pooled since filing, none have leased or otherwise committed their interest to the Austin Other 1920 DSU. Accordingly, the full list of names that are listed on the request for agency action on page 2 remain to be pooled here today. In addition, as addressed in paragraphs 17 and 18 of Mr. Dean's declaration, several estates are also named to be pooled. SM believes it has leased voluntarily pooled most of the successors of these estates, but can't be certain of that due to lack of sufficient distribution. Accordingly, SM provided the requisite notice of opportunity to participate to the estates and claiming by, through, or under the estates by publication as authorized by the board via order entered on September 11th, 2025. Only one response material to the request was received. Excuse me, the estate of Becky E. Estep has been removed as SM has received sufficient evidence that this interest is voluntarily committed to the Austin Other unit. All the other estates, except the estate of Becky Estep, that are identified on page 3 of the request remain to be pooled here today. As reflected in Exhibit 8 on file and discussed in paragraphs 30 and 32, 30 through 32 of Mr. Dean's declaration, the acreage weighted average landowner royalty as of the date of spud of the first of the subject wells in this unit is 14.980465%. Costs, including plugging costs incurred, are just and reasonable, and the risks incurred in drilling the subject wells justify the imposition of a 300% risk compensation award. All is discussed in Mr. Peterson's declaration on file. And with that brief summary out of the way, I'd like to move quickly into the testimony of the witnesses and confirmation of the declarations. As I said, Mr. Dean will go first. He has yet to testify before the board. So, Mr. Dean, can you please state your name and business address for the record?
Absolutely. My name is Levi Dean, business address of U.S.M Energy Company, 1700 Lincoln Street, Suite 3200, Denver, Colorado, 80203.
Okay. And what is your position with SM?
I'm a senior landman.
Okay. Then does that give you responsibilities over the unit we're discussing here today?
Yes, it does.
Okay. Before I move any further, you've probably heard me say we need to qualify you as an expert. I know you're an expert. You know you're an expert. We got to prove it to all these people in the room here. Talk through your resume, if you would. Tell the hearing examiner in the division a little bit about your experience, starting with kind of your education and some of your work experience that you believe makes you qualified to be an expert in petroleum land management.
Absolutely. So I hold a Bachelor of Arts in Business Administration with an emphasis in energy management from Western Colorado University. Graduated in May of 2013. Since that time, I've worked for several operators, both in the Uinta Basin as well as other basins in Texas. Started out with Newfield Exploration, which is no longer in the basin, but interned with them in 2012. Started with them as a landman one. I had responsibilities over the Greater Monument View unit, which some of you may be familiar with, just south of SM's position. Since that time, became a landman too. I got laid off by Newfield, rehired by Newfield, moved to Houston, and I was over Newfield's horizontal program in the Central Basin, which is directly south of SM's position. In that role, I was responsible for balloting, negotiating lease transactions, negotiating JOAs with non-operators. And then after that, I worked in the Permian Basin for Ovintiv, who ultimately acquired Newfield Exploration. Worked Permian Basin for them, and then Eagle Ford for them. After that, I got the Eagle Ford asset ready to sell. Once that happened, they no longer required my services. In late 2020, I worked for a broker doing some abstracting in Colorado. And then I worked for a utility scale renewable company that's actually based in Salt Lake City. Worked for them remotely from Denver, Colorado. I was responsible for negotiating for transmission lines for several solar and hydropower projects. Started with XCL Resources, who is SM's predecessor in interest in these lands in early 2023. Continued to ballot, negotiate leases, negotiate JOAs, work on lease acquisitions, as well as trades, doing mostly the due diligence piece of it, as well as preparing exhibits for forced pooling hearings. Then I was hired by SM Energy Company January 1 of 2025, and continue working in the basin since then in a similar capacity.
Okay, thank you. I don't have any follow-up questions, but I'm going to let the division and hearing examiner ask you questions, if that's all right.
Absolutely.
To designating Levi Dean as an expert witness.
And I don't have any other questions technically.
Okay, then as long as he's admitted as an expert or recognized as an expert.
Yes, I'll recognize him as an expert in this matter
Perfect.
in his capacity as a landman.
Okay.
But let me ask,
Yeah.
will this now serve for all the other matters today?
Assuming you guys are fine recognizing him as an expert going forward, this will be the last to qualify him. But you're always welcome, even if someone's been proved as an expert, to ask questions at any time.
No, that's fine.
Mr. Dean, thank you. So moving on quickly, you've obviously, well, I won't say you've obviously, I will ask you, do you recognize the exhibit that's numbered 11 titled Declaration of Levi Dean Testimonial?
Yes, I do.
And are you familiar with all the allegations that are outlined in the declaration?
Yes, I am.
Okay. Did you execute the declaration?
Yes, I did.
And does the declaration, as conformed to what you've heard here today about this matter, represent your full and complete testimony here before the hearing examiner?
Yes, it does.
Changes or corrections, or modifications you'd like to make?
Not at this time.
One last question then, in your expert opinion, you've now been deemed an expert, are the terms of the JOA that's at issue here today reasonable and just and customary in the Uinta Basin?
Yes, they are.
Okay. I don't have any further questions for Mr. Dean, subject to the division and hearing examiner cross-examining.
A couple of questions for Mr. Dean. You indicate in your declaration, and I forget which paragraph, that the JOA allows for a higher non-consent penalty than what is being asked for.
That's correct.
But you are comfortable with the imposition of a 300% non-consent penalty in this matter?
Yes, I am.
Okay. And then on paragraph 29, where it talks about the estate of Becky E. Estep, and Mr. Merrill already mentioned that. There's also a subparagraph to that where Wells Fargo 1 and 2 are also indicated as being removed. Can you explain to me how that comes about?
Sure. As far as the estate of Becky Estep, we were provided sufficient documentation that her estate had been distributed. And as far as Wells Fargo goes, we're not removing them from the request. They reached out to us through council because they own an unleased mineral interest. So they were kind of asking about a little bit of the history behind it. I don't think they realized they owned an interest in the unit. So I provided the vesting documents, their successor in interest to First Security Bank of Utah. So they're made aware that they have an unleased mineral interest. They had an opportunity to participate, to lease, or if they wanted to sell their interest, we'd be interested in that as well. We have not had any further communication from them since early last week, since I provided that information to them.
And they certainly could have represented themselves today if they wanted to.
Correct, yes.
Division, do you have any questions?
No questions.
Okay. I guess we just move on at this point.
At this point, we can move on to Brad Peterson.
Okay.
Levi, hang tight. You'll be around more, but we'll let Brad go for a minute. Brad, if you could state your name and confirm your business address for the record.
Yeah, it's Brad Peterson, 1700 Lincoln Street, Suite 3200, Denver, Colorado, 80203.
Okay, and you've already been recognized, if you will, as an expert in petroleum reservoir engineering for this cause. But can you remind everyone what your job title and your responsibilities are relating to this unit?
Yeah, I'm the Utah Asset Manager. I'm responsible for all development, planning, optimization, and execution.
Okay, and assuming that includes this unit, right?
Yes.
Same questions, similar questions to what I asked Mr. Dean. Are you aware of, familiar with what's been filed as Exhibit 12, the declaration of Brad Peterson in this cause?
Yes.
Okay. Are you familiar with all the allegations that are in there?
Yes.
Did you execute the declaration or cause it to be executed by council? And does the declaration lay out your full and complete testimony here? Are there any modifications necessary today?
Yes, no modifications.
Okay. One last question for you. In your expert opinion, well, I guess a couple questions. Do you believe the actual cost for these wells, the 3 wells at issue, are fair and reasonable and necessarily incurred and within a reasonable variance of the estimated costs in the AFE?
Yes.
Do you believe the risks discussed in your declaration justify the imposition of the 300% risk compensation award here?
Yes.
Okay. With that, I don't have any further questions for Mr. Peterson, subject to confirmation or questioning.
I just have a couple of questions. Since this is my first time experiencing the 3-mile laterals, and I mean, when I left the division, we were still at 2 miles.
Yep.
But Mr. Peterson, the batch drilling of wells, you talk about that in your declaration. Could you go into that a little bit more and tell me how that works and how many wells are drilled at a time? That sort of thing.
Yeah, so our whole development plan is really trying to minimize coming back in areas of depletion and kind of trying to be as efficient as we can, both from a surface disturbance as well as, from an execution standpoint. So when we talk about batch drilling, we're basically drilling, and we're kind of we basically drill a pad and we keep drilling all the wells that we plan to drill, kind of sequential. And then behind it, we have the completions crew that we keep about a mile off our drilling rigs due to, we don't want to be pumping high pressure at our drilling rigs for safety. And then we'll batch drill all these wells, which really just gets to be that we're not doing one-off wells kind of all over the field for like delineation. we're drilling that kind of all the wells off the pad in the targeted formations, and then we'll complete them all, and then we'll bring them all online. So we're not getting individual well set data prior to drilling and completing wells, across the acreage. So there is an inherent more kind of capital that we put into it all at once. So for example, it's roughly $31 million for these 3 wells that we drilled here on these pad. And then, as you can see, the cost came in just a little bit higher than that. So there's always risk mechanically, as well as, from a subsurface standpoint, that is inherent in these developments.
So for each of the wells that you're talking about, these Bigglesworth wells, you originally estimated a little over $10 million per well, and the actual cost ended up over $12 million. That's about a 20% cost increase. What you're saying, that is reasonable in terms of the cost increase per well?
Yes. Yeah, it's reasonable. I think, for us, usually we don't have to even let partners know unless less costs go over by 20%. So this is, less than that threshold. So yeah, they're a little higher than definitely we would like, but they are reasonable.
Okay.
Can I ask a quick question just for the record, Mr. Peterson? Were these the first 3-mile wells that were drilled by you?
Yeah, they were the first 3-mile wells that were drilled by XCL in the basin.
One other question: were you guys involved? Was SM an owner or involved at the time of the estimating of costs, or was that done by XCL? Was the actual costs? Can you guys kind of give us a sense of where you guys came into when the economics were figured out on these wells?
Yeah, we were involved completions forward, and then like you had mentioned, they came online early January, so we would have brought them online in January.
Okay, so the AFEs, those went out before you guys were even a thing.
Yeah, that's correct.
Okay, all right, thank you. Sorry, just wanted to.
Yeah, that's a good point. There's obviously a learning curve with the new company.
Well, and yeah, different companies, different ways of doing things.
Sure.
Different
3-mile wells.
And I don't know if this is a question for you, Mr. Peterson, or for Mr. Dean, but Mr. Mayo indicated that there was a difference between the spud date, I think, in January versus what was in the request. Does that change the accounting for these wells at all, having that difference in dates?
It's probably one I can answer easiest. So the date, it wasn't the spud date. The spud date would change the accounting because that's when the acreage weighted royalty is calculated. It's based on the spud date. What the date of first production, and that just impacts the timing of when this pooling order is effective. So if you decide to grant the order here today, the order will go into effect as of the date of first production, which is January 7th, not June 7th. So that's the.
Understood. Thanks for that clarification.
Yeah.
Well, let me ask then, Division, do you have any questions?
Division has no questions.
Okay. Well, that's great. I think we're going to be accepting this testimony in just a minute. So let's have, anything you wanted to ask? Okay. All right. Let's have closing statements. Let's start with the Division. And the Division, I believe you've sent in a response already.
Yes, sir. The division filed the response, I believe it was titled Notice of Non-Opposition to the Request for Agency Action. And the division maintains that position here today. The division is not opposed to the hearing examiner granting the request before you.
Okay. Mitch, do you have a ending statement?
Yeah, my close. I probably should do a couple housekeeping things. One, move for admission of exhibits 1 through 14. That includes the declarations to the extent they were modified orally today. But I'd like to move for the admission of exhibits 1 through 14.
Okay, I believe that's in order.
Okay.
So we
Approved.
accept those.
Okay.
No objections.
Perfect. And I won't take long, but I think we've met all the statutory requirements, and I think we're in a position that the hearing examiner can approve the request and should approve the request. And with that, I thank everyone for your time and attention.
Okay. Well, like I said, I've reviewed the request. I've looked at all the exhibits and the declarations that were filed. I'm ready to make a finding. Is that okay? So I find that U.S.M Energy Company has provided sufficient notice of opportunity to the non-consenting parties, and that those owners identified in the request for agency action did not timely elect to participate in the wells, and therefore should be deemed non-consenting parties. I find that the 300% non-consent penalty is fair and justified given the economic and geologic conditions present, and find that it would be appropriate to impose the requested non-consent penalty. And I also find that U.S.M Energy Company has met its burden of proof to show that it's entitled to the forced pooling of the named interests and other relief requested. So, Mr. Mayo, I'll ask you to prepare the proposed order.
I'm happy to do that, and I talked with the counsel for the division. I'm going to hopefully get him a draft today to start working on revising.
And with that, I will present the findings and conclusions to the board at their next regularly scheduled meeting, and the board will be able to vote on that fully.
That's right. Mr. White, do you want to be copied on the draft, or once we get a finalized draft, then involve you? And
Yeah, the latter.
happy to do. We'll get that circulated quickly.
Okay. Any other comments before we close this matter?
No, sir.
Okay. Well, thank you to everyone. Thank you to the staff and the division. And thanks to especially for those who allow this electronic participation to take place. Thank you so much. And we'll adjourn this proceeding. So give me just a minute. We'll move on to the next. Does anyone need a break? I know that I've got this one to do, and then we'll be turning it over to John Rogers so we can take a break then.
That makes sense too, yeah.
Yeah, we'll get right. That's good.
This one will hopefully be a little quicker because we don't have to qualify. We've got some of that stuff out of the way. So.
Are we still live?
We are still live.
Okay. Then I'll just jump right into the next one. Give me just a minute to turn to that matter. Some of this will be repetitive, so forgive me.
Me too.
So good morning, everyone, and welcome. My name is John Baza. I have been appointed by the Board of Oil, Gas, and Mining as a hearing examiner in this proceeding. Today is Wednesday, February 18th, 2026. This is the time and place for the hearing examiners proceeding for docket number 2025-050, cause number 132-82. This is in the matter of the request for agency action of U.S.M Energy Company for an order pooling interests, including the compulsory pooling of the interests of certain non-consenting owners within a 1,280 acre or substantially equivalent drilling unit established for the production of oil, gas, and associated hydrocarbons from the Lower Green River-Wasatch (Colton) formations comprised of sections 30 and 31, Township 2 South, Range 1 West, U.S.M, Duchesne County, Utah. We're holding this hearing with an anchor position in the Department of Natural Resources building in Salt Lake City, Utah. Before we begin, are there any members of the public or respondents present that wish to comment on these proceedings? Is there anyone online?
There are no members of the public online.
Okay, so the record can show that there's no public or respondents present other than members of the staff that are here today. I will take appearances of counsel at this time.
Thank you, Mr. Hearing Examiner Mitch Mayo of Lear & Lear PLLC on behalf of the petitioner U.S.M Energy Company.
Okay, and for the division.
Assistant Attorney General Nico Micheletti on behalf of the division. With me today is Peter Pankey and Spencer Nish, division experts.
Okay, thank you very much. And I have as counsel for the hearing examiner, Mr. Gary Wyatt, also with the Attorney General's office. So some housekeeping matters again. I've received the declarations from Mr. Levi Dean and Mr. Brad Peterson for this matter. I've reviewed them and the exhibits that were filed prior to this proceeding. Does the division have any objections to these declarations?
No objections.
Okay. With that, I will let Mr. Mayo proceed because I think you're capable of handling all the other housekeeping.
I'm happy to hop in and give you a break if nothing else. How about that? Thank you, Mr. Hearing Examiner. As you said, SM Energy Company with us today are Mr. Levi Dean, raise a hand for the camera if you would again, and Mr. Brad Peterson, same thing. These witnesses are appearing remotely from their offices by order entered by the board on February 10th of this month, allowing electronic participation. These witnesses were sworn in a prior matter. I assume it's probably appropriate to either advise them they're still under oath or to administer a new oath, but I'll allow hearing examiner counsel to.
I think it's okay to keep them under oath at this point.
I'd like to remind you guys, you're both still under oath. Everything you say is your sworn testimony here. This matter, again, was filed as the matter previously was filed in September of last year and has been continued a couple times for various reasons. We appreciate the patience and the rescheduling to get this teed up here today. Pursuant to informal agreement and now formal approval, I guess, from the division, Mr. Dean and Mr. Peterson submitted declarations, sworn written testimony prior to this hearing to allow everyone a chance to kind of vet their testimony and review the applicable regulations prior to the meeting here today. These declarations were filed as Petitioner's Exhibit 12 and Petitioner's Exhibit 13 on February 10th of 2026, and both Mr. Peterson and Mr. Dean are here to answer any questions you have about those. Mr. Dean was recognized as an expert in the prior cause number 132-81, and Mr. Peterson has been recognized numerous times, most recently in the cause earlier today, but also in January in cause number 130-46. Presuming stipulation of division and hearing examiner, I'd like to move to have these both considered as experts here for purposes of this cause.
Division.
No objection.
No objection from the division.
Okay.
We will recognize them as experts for this matter.
Thank you. The board and the hearing examiner by delegation has jurisdiction over this matter pursuant to Utah Code 40-6-6.5 and the implementing regulations. A copy of the request in this cause and of the notice of opportunity to participate was sent by certified mail to the known parties sought to be compulsorily pooled and sent by regular mail to all other production interest owners within the drilling unit at their last known addresses disclosed by the relevant county realty records and by SM's internal records. These mailings included to all relevant institutional parties to the extent they owned an interest in the unit. Those are, Trust Lands Administration, DFFSL, and federal agencies, etc. These mailings were all sent as outlined in paragraph 26 of Mr. Dean's declaration and as outlined in the certificate of service on file filed on September 15th in this cause. What's more, proof of the mailings in this matter and of invalid addresses, if any, for each of these parties is included in Exhibit 15, Proofs of Service, which was filed separately on January 22nd, 2026. In addition, notice of the filing of the request and of the hearing here today was duly published following board authorization in the Uinta Basin Standard on September 24th and October 1st, 2025. Exhibit 14 on file is a true and correct copy of the affidavit of these publications. Lastly, on February 10th, the division filed a notice of non-opposition to the request pending a satisfactory presentation of evidence and discussion here today. And I'd like to remind everyone that no other objections or responses were timely filed or are pending here today, so we're free to move ahead. This cause involves the compulsory pooling of a 2-mile, 1,280-acre drilling unit established by board order on July 18th, 2016, in cause number 139-138, which was subsequently modified by order in cause number 130-29. I may refer to these collectively as the current orders. This unit was set up for Lower Green River-Wasatch, parentheses, Colton production, and this unit comprises the entirety of sections 30 and 31, Township 2 South, Range 1 West. I may call this the Austin Powers unit, the Austin 1280 DSU. In accordance with the current orders, a copy of which is attached as Exhibits 2 and 3 of Petitioner's Exhibits, XCL Resources, XCL Asset Co., as the predecessor in interest to SM Energy, drilled the following wells, and SM now produces from the following wells, producing from the Austin Powers unit and identified in the request. These wells are the Bigglesworth 63-3130-21D well, which spud on May 6, 2024, with a date of first production of January 7th, 2025, and the Bigglesworth 47-3130-21F, which spud on May 10th, 2024, and also had a date of first production of January 7th, 2025. There are 10 owners of undivided oil and gas interests in the subject unit and subject wells that were named on page 2 of the request as required to be pooled because they have refused or failed to lease or otherwise participate in the wells. Although SM has had conversations since filing the request with some of the owners of interest to be pooled, none have elected or otherwise committed their interest to the Austin 1280. Accordingly, the full list of names identified on page 2 of the request remain to be pooled here today. Also, as discussed in Mr. Dean's declaration, several estates are named to be pooled. SM believes it has leased and voluntarily pooled all successors of such estates, but can't be certain. So the estates have to be pooled out of an abundance of caution. In order to accomplish this, SM provided the notice of opportunity to participate to the estates and anyone claiming by, through, or under them by publication as authorized by this board by order entered on September 11th of 2025. Exhibit 14 on file is a true and correct copy demonstrating the affidavit of publication. Only one response material to this request was received from that publication. The estate of Becky E. Estep, as in the prior cause, has been removed in this cause due to essentially SM receiving sufficient evidence that that interest is fully committed to the unit. As reflected on Exhibit 9 and discussed in Mr. Dean's declaration, the acreage-weighted fee landowner's royalty as of the date of the spud of the first of the Bigglesworth wells at issue is 16.853057%. And the costs are just and reasonable in this matter, and the risks justify the imposition of the requested risk compensation award. And with that, I'll just jump into my testimony or my examination of Mr. Dean. Mr. Dean, if you could state your name and business address for the record.
Levi Dean, 1700 Lincoln Street, Suite 3200, Denver, Colorado, 80203.
Okay, and your current position with SM and your responsibilities over the subject unit.
Sure, I'm a senior landman, oversee this unit for title purposes, as well as doing the balloting.
Okay, and I'd like to remind everyone, Dean's testimony, his declaration testimony and anything today is offered as expert testimony in petroleum land management. Mr. Dean, are you aware of and familiar with what's been filed as Exhibit 12, the declaration of Levi Dean on file in this cause?
Yes, I am.
Have you reviewed that, and are you familiar with all the allegations contained in it?
Yes.
Okay. Did you execute or cause your counsel to execute on your behalf the declaration?
Yes.
And does the declaration, as discussed here today and as filed, represent your full and complete testimony in this matter?
Yes, it does.
Any clarifications or revisions before I turn you over to the division and hearing examiner?
No.
Okay. With that, I don't have anything further for Mr. Dean pending cross-examination.
Okay. I have similar questions as in the previous matter. Rather than repeat those or go through that same explanation, I'll just refer anyone to that previous matter for that information. There was one thing that Mr. Mayo mentioned in his summary statement that this involves trust lands, but I believe this drilling unit excludes those trust lands from the previous matter. Is that correct?
That is correct.
Okay. So there are no trust lands in this
Thank you.
particular.
Good
drilling.
clarification.
And division, do you have questions for this witness?
No questions from the division.
Okay, appreciate that. Mr. Mayor, you may proceed.
Thank you. With that, Mr. Dean, there's nothing further. If you'll just hang tight in case something comes up. Mr. Peterson, can you please state your name and business address for the record?
Yeah, it's Brad Peterson, 1700 Lincoln Street, Suite 3200, Denver, Colorado, 80203.
Okay. And what is your job title and responsibilities generally and with respect to this unit?
Yeah, I'm the Utah Asset Manager, responsible for all development planning, optimization, and execution.
Okay. Are you aware of what's been filed as Exhibit 13 in this cause, the declaration of Brad Peterson?
Yes.
You're familiar with all the allegations that are contained in that declaration?
Yes.
Did you execute it or cause your counsel to execute it on your behalf?
Yes.
Are there any corrections or clarifications you would like to make to that declaration here on the record?
No.
Okay. In your expert opinion, are the actual costs incurred fair and reasonable and necessarily incurred in this matter?
Yes.
And are they within a reasonable variance of the AFE estimated costs?
Yeah.
Okay. Last question. Do you believe the risks incurred in this development, especially considered as part of a broader development of these several units, justify the imposition of the 300% risk compensation award?
Yes.
Okay. With that, I have no further questions pending division and hearing examiner satisfaction.
And again, I will refer anyone who's reading this information, refer to the previous matter for the questions that I asked Mr. Peterson.
And then no questions from the division.
And no questions from the division, so
Okay.
we're done with that.
Well, then it's probably appropriate for me to briefly sum up. I'd like to move for the admission of exhibits 1 through 15. That includes the declarations that we discussed, declaration 11 or 12 and 13 in this cause.
Any objections?
No objections.
And before we go further, maybe I'll ask the division, because of the response the division filed, do you want to summarize that?
Yes, sir. On February 10th, the division filed a responsibly titled Notice of Non-Opposition to the request for agency action, and it maintains its position here today and does not oppose the hearing examiner in granting the petitioner's request for agency action.
Okay. So with all that, we'll admit our exhibits, Mr. Mayo.
Perfect. With that, I would just say that I believe SM has met the statutory and regulatory requirements necessary to pool this, and that this unit should be pooled for the just and equitable production of the minerals in the area. And with that, I thank the hearing examiner and everyone here for their time and attention.
All right, appreciate that. Well, with that, I will present certain findings. First of all, I find that SM Energy Company has provided sufficient notices of opportunity to the consenting parties, and that those owners identified in the request for agency action did not timely elect to participate in the wells and therefore should be deemed non-consenting parties. I find that 300% non-consent penalty is fair and justified given the economic and geologic conditions present with these wells. I find that it would be appropriate to impose the requested non-consent penalty. I also find that SM Energy Company has met its burden of proof to show that it is entitled to forced pooling of the named interest and other relief requested in the request for agency action. So, Mr. Mayo, I'll ask you to prepare a proposed order, and then I'll present these findings to the board at their regularly scheduled meeting next week.
I'm happy to do that, and I'll try and get that order circulating today to get the process started.
Okay? Any other comments? before we close. Very well. I thank everyone again, and I thank staff for participation and especially for the ability to conduct an electronic meeting today. We'll adjourn this proceeding. Thank you.
Thank you. Hold on just a minute, guys. We got to swap out hearing examiner. Mr. Boz is done, so we'll maybe be milling around for a minute, but stay close.
I'm done. Listen, see,
Oh,
he gets
And I give you the other two.
see, he does it right.
Carmen, we're gonna go ahead and continue with our live broadcast and just switch hearing examiners.
Hearing examiner proceedings, you are live.
Do you approve? We're kind of off the record. Do you approve of the well naming based on movie characters? Everyone here quite enjoys it for what it's worth.
You gotta get some humor in this.
He's on mute, so if he's objecting, we can't hear him.
I had this room on mute, so he wasn't privy to all of the conversation we had, so.
So 009, all right.
So if
Yes, so we
this
are
one is as is,
on,
right?
yeah, we're on matter 13283,
Okay, gotcha.
as I'm saying we are, I guess.
Did we lose anyone or are we?
I think we're ready to go.
Division's ready.
Petitioner's ready?
Gladiators ready.
Stated yourself. Thank you.
It's okay. It's
Time for your back meds after that one.
good times.
You too?
We're good.
Okay.
Yeah.
All right,
we are on.
I was waiting.
We're good to go.
Okay. Good morning. My name is John Rogers, and I'm Environmental Manager with the Utah Division Oil, Gas, and Mining. I've been appointed by the Board of Oil, Gas, and Mining to act as a hearing examiner of this proceeding. Today is Wednesday, February 18th, 2026, and this is the time and place for the hearing examiner proceeding for docket number 2026-009, cause number 132-83. in the matter of request for agency action of SM Energy Company for an order pulling all interest, including the compulsory pulling of interest of certain non-consenting and unknown owners within a 1,280 acre or substantial equivalent drilling unit established for the production of oil and gas and associated hydrocarbons from the Lower Green River-Wasatch Colton formations comprised of Section 29, 32, Township 2 South, Range 1 West, U.S.M, Duchesne County, Utah. We are holding this hearing with an anchor position in the Department of Natural Resource Building in Salt Lake City, Utah. There will also be hearing testimonies and presentations in person and virtually, and the proceedings will be broadcast on the internet. Before we begin, there are any members of the public or respondents present that wish to comment on these proceedings? Matt, do we got anyone online?
There are not any members of the public online.
Let the record show no public respondents are present. We'll take appearance of counsel at this time.
Thank you, Mr. Rogers. Mitch Mayo of Lear & Lear PLLC on behalf of the petitioner SM Energy Company.
Thank you, Mr. Rogers. Nico Micheletti, Assistant Attorney General with the Division of Oil, Gas, Mining today. And with me is Peter Pankey and Spencer Nish, Division Experts.
Thank you.
I'm Gary White, Assistant Attorney General, Counsel for the hearing examiner.
Thank you. Some procedural items to begin with. I've received declarations from this matter from Mr. Levi Dean, a senior landman for SM Energy, and will be testifying to issues of petroleum land management. Also, Mr. Brad Peterson, the Utah Region Asset Manager for SM Energy. He will be testifying as a petroleum reservoir engineer. I reviewed both of these declarations before this hearing. Mr. Mayo, I understand that both Mr. Dean and Mr. Peterson have testified before in the previous hearings at this time, and they were accepted as expert witnesses for that matter. Does the division have any issues or with them being accepted as expert witnesses today?
No objections.
Okay, thank you. Mr. Dean will be accepted as an expert witness in petroleum land management, and Mr. Peterson will be accepted as an expert in petroleum engineering and reservoir engineering. Okay, and also we've had them sworn in the previous matter. I'm okay with them continuing under that oath.
Okay. I'd just like to remind them, Mr. Dean, Mr. Peterson, nod if you can hear me. You guys are both still under oath for this cause. I just want to make sure you're clearly aware of that. Thank you.
And division, you okay with that?
Yes, sir. Yes, sir.
Okay. Okay, we'll proceed to Mr. Mayo for his presentation.
Thank you. Mr. Hearing Examiner, you already admitted them as experts, right? I
Yeah.
glossed over that in my brain. Okay, thank you. Yeah, so both witnesses are here today, as is past practice before the hearing examiner. The declarations were filed last week to give everyone an opportunity to review their factual testimony. And both witnesses are here today to essentially authenticate those declarations and answer any questions you have about them. The board and by delegation, the hearing examiner have jurisdiction over this matter pursuant to Utah Code 40-6-6.5 and the implementing regulations. A copy of the request and the notice of opportunity to participate was mailed out to all relevant parties at their last known addresses of record in the county records and in SM's internal records. These mailings were sent as outlined in the declaration of Levi Dean and as identified in the certificate of mailing on file as December 15th in this cause. Evidence of the return receipts for these mailings was also filed as Exhibit 15, filed on February 9th. In addition, notice of the filing of this request and of this hearing was published following board authorization in the Uinta Basin Standard on December 31st, 2025, and January 7th, 2026. Exhibit 14 on file is a true and correct copy of the affidavit evidencing this publication. On February 10th, as mentioned, the Division of Oil, Gas, and Mining filed a response expressing no opposition to the granting of the request pending a satisfactory presentation here today. I'd like to remind everyone no other objections or responses were timely filed and none remain pending here today. I'd like to summarize this case by saying, this involves, again, the compulsory pooling of a 2-mile or 1,280 acre drilling unit. This unit was established in cause number 139-138 as modified in cause 130-29. These may be referred to as the current orders. The unit is established for Lower Green River-Wasatch, parentheses, Colton formation production. And the unit is comprised of the entireties of sections 29 and 32, Township 2 South, Range 1 West. I will probably refer to this as the Anchorman unit or the Anchorman 1280. In accordance with the current orders, and a copy of which, in accordance with the current orders, and I'd like to note that Exhibits 2 and 3 on file are true and correct copies of those orders. XCL Asset Co., as the predecessor in interest to SM, drilled the wells, and SM now produces from the wells identified in the request. And there are 10 wells identified in the request. They're all lamp wells. I won't go through and read the information for each well on the record, but I'll refer you to the request for agency action. One thing I will note is the spud dates. And, well, actually, we'll get into that later. The well completion reports identifying the date of first production are still unavailable on the division's website as of today. But I'm going to ask Mr. Dean to go through in his declaration testimony and confirm the date of first production, the effective date of the order here in this cause. There are 19 owners of undivided oil and gas interests in the Anchorman 1280 unit and the subject wells, and they were named to be pooled on pages 2 and 3 of the request. None of these named parties have, since filing of the request, leased or otherwise voluntarily committed their interest to the Anchorman unit. Accordingly, that full list of names identified on pages 2 and 3 of the request remains to be pooled here today. In addition, as discussed in paragraphs 17 and 18 of Mr. Dean's declaration, there are several estates named to be pooled in the request. SM believes it has leased and voluntarily pooled all successors or heirs of said estates. However, because of the lack of sufficient distribution, SM is required to pool the estates out of an abundance of caution, and accordingly provided the requisite notice of opportunity to participate to the estates and anyone claiming by, through, or under them by publication as authorized by the board. The full list of estates identified in the request for agency action remains to be pooled here today. As reflected on Exhibit 9 on file and discussed in paragraphs 30 to 32 of Mr. Dean's declaration, the acreage-weighted average fee landowner's royalty as of the date of spud of the first of the subject wells is 16.986801%. Mr. Dean, I'd like to start with you. Can you please state your name and address for the record?
Levi Dean, address is 1700 Lincoln Street, Suite 3200, Denver, Colorado 80203.
Okay, and what's your job title generally and how it relates to this unit?
Senior landman, oversaw the balloting as well as title issues in this unit.
Okay, and your resume, and you testified earlier, you worked for XCL prior to this, so you actually did work on the balloting for XCL, and now the pooling in for the, correct?
That is correct.
I want to ask you just a couple questions about Exhibit 12, the declaration of Levi Dean. Do you recognize this exhibit?
Yes, I do.
And are you familiar with all the allegations that are contained in it?
Yes, I am.
Did you sign it or cause your counsel to sign it on your behalf?
Yes, I did.
And does that declaration represent your full and complete testimony here today?
Yes.
Modifications or revisions necessary?
That's correct.
Okay. One question in my intro I alluded to, and I wanted to have you just hit on it for me, if you wouldn't mind. The effective date of this pooling order. As you're aware, the pooling orders are in effect as of the date of first production of the first subject well that's pooled. Can you identify, in the request for agency action, I believe we identified January 20th, 2025 as the date of, the effective date essentially of the pooling order requested? That's not accurate, is it?
No, it is not.
Can you tell everyone here what the actual date of first production is and what the effective date of this order should be if approved?
Yes, that's January 17th, 2025.
Okay. January 27th.
That's correct.
January 27th. That's okay. Sorry. So
that was first production.
that's the date of first production. So we identified it in the request mistakenly as January 20th, when actually the first of these wells produced on January 27th.
What
I
year?
don't believe there's any harm in the order being effective a week before, but just to make it accurate, that is 2025. So January 27th, 2025. Correct, Levi?
That's correct.
Okay. With that, I have no further questions for Mr. Dean, pending division or hearing examiner questions.
Division?
No questions from the division.
Okay. I got a few questions here, and they may be very simple. I get a lot of calls of people asking about these things and what's going on. And so I would like to summarize, as I read through these documents from various attorneys, various companies, they use a lot of different terminology in this process. So I would like to summarize things and tell me if I'm wrong, right, or in between. Okay, there's three options. There's the non-consenting compulsory pool parties.
Okay.
Then there's the working interest owners, those that choose to participate.
Okay.
And then there's those that want to lease willingly.
That's right.
Okay, then as we use these terms, consenting parties, estates, deceased, unknown, unlocatable, choose not to participate in the lease, they all fall into one of those categories, and you then pull them up in one of the three?
Basically.
Okay.
Yeah. One of the hard things about being a lawyer is trying to make legal writing make sense to anyone but lawyers. And so one of the ways we try and do that is we try and take these complex sentences or themes and give them a short site, consenting parties, so that we don't have to reiterate that same dense language every time, but also so that people can just, understand the generality of what we're getting at. So there are a lot of ways we short site, that we identify things, but in the end, we do try and kind of bring them all back together. Non-consenting CP parties is kind of the primary one that you need to worry about in most of these. And that's just all the parties that are going to be pooled and that are subject to imposition of the pooling order in the cause. Consenting parties is everyone who's kind of voluntarily participated.
Okay, explain to me unknowns and unlocatables.
Well, what I'll say is, typical example of an unlocatable is I go through title and I see that John Rogers owns 50% of the minerals and Gary White owns 50% of the minerals. And you have an address and you have an address listed. I send you both letters with a lease offer. You sign your lease and send it back to me. The one I send to Mr. White gets returned undeliverable. If I search online and I do all the work I can to find Mr. White, but I can't, we would come before the board and say he is unlocatable. We know who he is, but we can't find a way to communicate with him. We can't find him. Unknowns typically are a couple different groups bunched together. One is it's often used to apply to all the heirs or successors of estates because we just don't know who they are. It could be a grandma or a stepson that no one's heard of. So we don't know the full list of people.
So they fall into the deceased estates?
Oftentimes, yeah. Sometimes we'll have a situation like in the last matter you're going to hear today where one of the parties is a company that's long since dissolved, and in its dissolution kind of panic, it filed a bunch of deeds that are confusing, it recorded some things, and so there's unknown claimants under this company. And so the unknown, the way I think of it is we just don't know exactly who it is we're trying to pool, but we know someone else owns the interest that we had here. We just don't know exactly who it is to identify it. So they're unknown. The unlocatables are typically, we're confident they own an interest. We just can't find them.
Okay. Can you see some of the confusion there?
I get confused by it, so I can totally understand the confusion. And that's why on a case by case, it's really important to ask the questions if there is confusion.
So first production was January 27th, 2025.
That's right.
When was the establishment of the unit?
You mean the order? The
Yeah.
order authorizing it was 2016.
Okay.
July of 2016.
And is it stand up till 80?
Yeah.
Okay. So, first question, what, those people that are being compulsory pooled, unknown, is that put into a account holding for them until they actually come light?
Mr. Dean, do you mind answering Mr. Rogers' question? He's kind of trying to figure out, so, we're gonna pool, or if approved, we're gonna pool some unlocatable parties' interests. Can you walk through what happens with those? If the board approves the order today, what do you do with next month's production for, a party you're pooling? And how is that treated? How do you just kind of walk through that process? If you
No, we hold that in a separate account for that particular owner. So any funds go into that account. I believe it's an interest-bearing account as well. And then we hold that until either someone comes forward and claims it and is able to back up the documentation, or if there aren't any title issues and the title is clear, then after a certain amount of time, it gets escheated to the state of last known residence.
Okay, so the unclaimed property funds most likely in any state that they used to live in.
That's correct.
So what happens to the fund from January first production 2025 till today?
Well, Levi, I'm gonna answer what I think he's asking to see if you can kind of confirm what I'm saying, and that's, essentially for the last year, this unit hasn't been pooled. You've had production, kind of what have you done with those interests, and do you make a change? Do you kind of move money over after this hearing's over if it's approved? Does that make sense?
Correct. Yes. Yes. Once the pooling is approved, then we'll go back and reconcile all of the production, all of the revenue tied to those interests, and break them out separately at that time once the pooling's approved.
So it's safe to assume you've got kind of an unleased bucket in another account right now that as soon as this pooling order is done, that will be distributed out and accounted for in all the different owner accounts.
That's correct. It'll be back to first production.
Okay.
So it's sort of in limbo from first production till pooling order.
Once the
It's
pooling
still
order
there,
is
it's
entered,
just
then they go
accounted.
shuffle it back into work.
Okay, thank you. Okay. Mr. Dean, I read your declaration and reviewed it, and you've already testified that that's your testimony. Do you have anything to add to that?
No, sir.
Okay. All right. Thank you.
Mr. Peterson, briefly, if I could get you to just state your name and business address once again for the record.
Yes, it's Brad Peterson, 1700 Lincoln Street, Suite 3200, Denver, Colorado 80203.
Okay, and your job title and responsibilities.
Yeah, I'm the Utah Asset Manager. I'm responsible for development planning, optimization, and execution.
Okay. Are you aware of what's been filed as Exhibit 13 in this cause, the declaration of Brad Peterson?
Yes.
Okay. You reviewed the declaration and all the allegations contained in it?
Yes.
Okay. Did you, did you sign that or have your counsel sign that on your behalf?
Yes.
And is that declaration represent your full and complete testimony here today?
Yes, it does.
Okay. Before I let you go, a couple quick questions about your expert opinion. Do you believe the costs were fair and reasonable and necessarily incurred and within a reasonable variance of the estimates?
Yes.
Okay. And do you believe the risks in this unit, especially as considered with the adjoining and overlapping units, justifies the 300% risk compensation award?
Yes.
Okay. I have no further questions for Mr. Peterson, subject to cross-examination as well.
Okay.
No questions from the division.
Okay, thank you. I have a question. We talk about risk. It's one of the more sensitive things about what we do here.
Yeah.
And we have a choice between 150 and 400%. Seems like we've landed on the 300 as a sweet spot. Mr. Peterson, could you address the risk in this well and why it's different than the previous matter, which is a 3 mile long drilling well, that had the same 300%. This is only 2 miles. Does that extra mile add significant risk? And just address the risk issues, how you come up with the 300%, if you could.
Yeah, I mean, so I think that there's really two big risks here that we kind of think about it. One's mechanical risk. So failure as you drill the vertical hole, as you drill the lateral down the well, really, that's when I talk mechanical risk, that's what we're talking about. Subsurface risk is really the risk in getting what we think is in there, in the reservoir out. So we have estimates, what is under the ground, how we're gonna, be able to drain those volumes, over time, and what kind of additional cost is going to be incurred. So the higher the water cut, the more expensive it is to develop and produce these volumes. So those are the two risks. I think, the subsurface risk, no matter on lateral length, that's always inherently there. We did drill kind of a pseudo exploration well off this in the LAMP 007, different zone, actually a zone that's the first one in the, in the entire basin. So that has the most risk by, considerable amount. I think the mechanical side of things, when you talk about 2 to 3 mile wells, we've drilled over 100 wells of 15,000 feet or longer in the Permian Basin. I know we're new to drilling longer laterals here, but we've actually looked at those statistics of how much were we able to get, not the full well drilled in a 10K versus a 15K. And overall, those statistics are very similar. So I think, as you push out further and further from that, there is a little bit more, additional risk, but, up through that lateral length, I think we have the data in some other basins that say that, it should be statistically very, very similar.
I was looking on the maps yesterday, and I noticed some of these wells, and not particularly yours, just a lot in the area, tend to have a surface location, then it corkscrews around, curves, and comes back in to establish the lateral. Does that add risk to the well?
Step outs. So we do try. So a couple things on efficiency, and and also being just prudent operators and trying to minimize surface disturbance. So like this Acreman, these 10 wells here, were drilled off this pad. They're off one pad, so trying to minimize that disturbance. But also we have to deliver our oil at, the trucks don't pick it up to truck it off unless it's 140 degrees. So we have to keep it heated to either, truck to Salt Lake City refineries or truck down to PRT to get on a train and transport out. So we do it for a couple different reasons. We also try to, there's houses in this area. We're at the kind of edge of Roosevelt. We try to work with landowners and really try to minimize surface disturbance as well as surface, kind of interactions and be easier for, the people that live out there. So for the most part, we either do kind of 1 or 2 pads per section development. There's a couple, how far we can step out. We can step out probably up to 3,500 feet is kind of where we're at. But sometimes there's things in the area that require us to be far enough, not in the center of the pad. So then we have to step out more. So yeah, I would say, as you step out, we've done a really good job on, we put in, they're called rotary steerable systems that allow us to not have so much tortuosity or and dog legs as we step out, that allow us to drill the wells successfully. So I think it's a little bit more cost the further you step out, but overall execution has been, we've been able to mechanically, there's no difference in mechanical execution up until that technical limit that we have set for those wells.
Okay, thank you. I think in the future it might be good to address risk with a separate exhibit, just knowing what's there and what the issues are. Even though it may be a little redundant from well to well, I think it's good to know where you're headed.
Well, I think that's, maybe to summarize, I think, Mr. Peterson, essentially the mechanical risk is kind of the same for every well going in. If it's 2 or 3 mile, it's kind of a boilerplate mechanical risk, certain zones, certain risks, certain water issue potentials. But there's the added financial risk. So we'll try and distill that into an exhibit in future matters.
Okay, thank you. Okay, Mr. Peterson, I've read your declaration, and you've noted before that's your testimony. Do you have anything to add?
No, I don't have anything else.
Okay, thank you. The division has filed a responsive notice of non-opposition to the request of agency action dated February 9th, 2026. Therefore, it's my understanding the division has no objection in the request for agency action, but reserves the right to update the response after receipt of evidence and cross-examination during the proceeding. Is that accurate, Mr. Mitchell?
Yes, it is. The division maintains its position of not opposing the petitioner's request for agency action.
Okay. I turn some time over to you if you have any questions.
No, sir. No questions for the witnesses or the council.
Okay. We'll take closing statements at this time from the petitioner and division. We'll start with SM Energy.
Thank you. No real closing, just first housekeeping. I'd like to move for admission of exhibits 1 through 5 and 7 through 15. This includes the declarations of the witnesses. Exhibit 6 was intentionally omitted in this cause. So
no objection in admitting those exhibits.
Okay. Anything else to add?
No.
And
so admitted.
So admitted.
Perfect. Is that, sorry.
Yeah. Okay.
And my last closing is, I believe SM's met the statutory and regulatory requirements for approval of the request. And I'd just like to thank everyone for their time and attention and ask you to approve the order.
Okay. Mr. Micheletti, does the division have anything to add at this time?
No, the division also believes that the petitioners met the statutory and regulatory requirements and would not oppose the hearing examiner recommending to the board or the hearing examiner grant the request for agency action.
Okay, thank you.
Thank you.
Okay, we've already moved for exhibits being accepted, and so I'll make a summation right now. Having reviewed the request for agency action, all exhibits, and having considered the evidence presented today, I find that SM Energy has provided sufficient notice of opportunity to non-consenting compulsory coal owners, and that those owners identified in the request for agency action did not timely elect to participate in the wells and therefore should be deemed non-consenting. I find that the 100% for surface equipment and the 300% for drilling costs as a non-consent penalty is fair and justified given the economic and geological conditions present with this well, and find that it would be appropriate to impose the requested non-consent penalty. I find that SM Energy has met its burden of proof to show that they are entitled to forced pulling of the named interests of other relief requested in their request for agency action. Mr. Mayo, will you please prepare the order?
I'm happy to do that, and I'll work to try and get that circulating today if possible, so you guys can have time to review it before next week.
I will then present the findings and conclusions to the board next week at the board hearing. Any other comments before we close?
Thank you.
Okay, we'll close at this time and adjourn this proceeding. Thank you.
You guys need a break, or are you good? We got one more to get through, probably another 30 minutes, 20, 30 minutes. Okay.
Hey, Carmen, I think we can just go on break on the YouTube real quick.
Good morning. My name is John Rogers, and I'm Environmental Manager at the Division of Utah Oil, Gas, and Mining. I've been appointed by the Board of Oil, Gas, and Mining to be a hearing examiner for this proceeding. Today is Wednesday, February 18th, 2026, and this is time and place for the hearing examiner proceedings for docket number 2026-014, cause number 132-85. In the matter of the request for agency action of U.S.M Energy for an order pooling all interests, including the compulsory pooling of the interests of certain non-consenting and unknown owners within a 2,560 acre or substantial equivalent drilling unit established for the production of oil, gas, and associated hydrocarbons from the Lower Green River-Wasatch Colton Formation, comprised of Section 29, 30, 31, and 32, Township 2 South, Range 1 West, U.S.M, Duchesne County, Utah. We are holding this hearing with the anchor position in the Department of Natural Resource Building in Salt Lake City, Utah. We will also be hearing testimonies and presentations in person and virtually, and the proceedings will be broadcast on the internet. Before we begin, are there any members of the public or respondents present that wish to comment on these proceedings?
There are no members of the public online.
Okay, thank you, Matt. We'll now take appearance of counsel this time.
Thank you, Mr. Rogers. Mitch Mayo of Lear and Lear PLC on behalf of the petitioner, U.S.M Energy Company.
Vision.
Assistant Attorney General Andrew Haynes on the behalf of the Division of Oil, Gas, and Mining.
Assistant Attorney General Gary White, representing the hearing examiner today.
Thank you. Some items before we begin. I have received declarations from the matter from Mr. Levi Dean, a senior landman for U.S.M Energy, and will be testifying to the issues of petroleum land management. Also, Mr. Brad Peterson, the Utah Region Asset Manager for U.S.M Energy. He will be testifying as a petroleum reservoir engineer. I've reviewed both of their declarations before this hearing. Mr. Dean and Mr. Peterson have both testified before this Board of Oil, Gas, and Mining as expert witnesses. Does the division have any questions for Mr. Dean or Mr. Peterson concerning their qualifications?
None at this time, no.
Okay, thank you. Do you accept them as expert witnesses?
Yes.
Okay. We then will accept Mr. Dean as the expert witness in land management, petroleum land management, and Mr. Peterson will accept it as expert witness in petroleum reservoir engineering. And Mr. Mayo, we'll proceed with your presentation at this time. Oh, we've already sworn them in, right? Let me address that. We have sworn them in the last 3 matters. No, 2 matters, 3.
Yep.
And so we will accept them as still being under oath. And you want to?
Yeah, guys, you heard that. Just nod. Good, Brad, Levi. You're under oath again. So no lying under oath, I guess, is the message today.
Okay. Division, you okay with that?
Yes.
Mr. Mayo is pretty harsh. He lays it on the line.
We got to draw a line somewhere, right? Okay, so you guys, appreciate you hanging in. One more matter to get through here today. Mr. Rogers, thank you. You've gone through some of my introduction, so I'm going to skip ahead. I'd just like to confirm declarations were filed on behalf of both witnesses as Exhibits 11 and Exhibit 12 that lay out their hearing testimony here today. And both witnesses are here to answer any questions and to authenticate those. The board and the hearing examiner have jurisdiction over this matter pursuant to Utah Code 40-6-6.5 and the implementing regulations. A copy of the request and all relevant pleadings were sent by certified mail to the known parties sought to be compulsory pooled and sent by regular mail to all other production interest owners in the unit. These were sent to their addresses, their last known addresses of record as established in the county records or in USM's updated internal records. These mailings were sent as outlined in paragraph 26 of Mr. Dean's declaration and as memorialized in the certificate of service on file in this cause with a filing date of January 15th of 2026. In addition, the proofs of service of these mailings or proof of invalid address, as it may be, for each of these parties has been filed as Exhibit 14 in this cause. In addition, notice of the filing of the request and this hearing was duly published in the Uinta Basin Standard on January 21st, 2026 and January 28th, 2026. Exhibit 13 on file is a true and correct copy of the affidavit memorializing this publication. On February 10th of this year, the Division of Oil, Gas, and Mining filed a response expressing no opposition to granting the request pending satisfactory presentation here today. No other objections or responses to the request were timely filed, and there are none pending as of the date of this hearing. Brief summary, as mentioned, this cause involves the compulsory pooling of 2,560.72 acre drilling unit. It was established by board order in June of 2021 in cause number 600-04. That was amended subsequently by cause 130-29. I may refer to these collectively as the current orders. The subject unit was established for Lower Green River-Wasatch Colton production, and the unit comprises the entirety of sections 29, 30, 31, and 32 in Township 2 South, Range 1 West in Duchesne County. I may call this the Austin Anchor 2560 unit. In accordance with the current orders, and I'd like to note that Exhibits 2 and 3 on file are true and correct copies of the current orders. SM's predecessor in interest, XCL Resources, drilled, and SM has now begun to produce from the 2 lamp wells identified in the request for agency action. The lamp 50-3229-21E, which spud on January 24th of 2024 and had a date of first production of January 27th of 2025. And the lamp 60-3130-21D, which spud on January 26, 2024, with a date of first production also of January 27th, 2025. This matter had the most number of owners to be compulsory pooled. There were 29 owners of undivided oil and gas interests in the Austin Anchor 2560 unit and the subject wells. These parties were named on pages 2 and 3 of the request for agency action. Although SM has had conversations with some of these owners and some prospective owners of these interests to be pooled, none have leased or otherwise committed their interest to the Austin Anchor 2560. Accordingly, the full list of names identified on pages 2 and 3 of the request remains to be pooled here today. There is one other notation. Actually, give me 1 second if I can to just confirm my. Perfect. In addition, as addressed in paragraphs 17 and 18 of Mr. Dean's declaration, there were numerous estates named to be pooled on pages 3 and 4 of the request for agency action. Although SM believes it has leased and voluntarily pooled all successors of said estates, it can't be certain because of the lack of complete distribution, and so we must pool the estates out of an abundance of caution. To accomplish this, SM provided the requisite notice of opportunity to participate to these parties, the estates, and the parties claiming by, through, or under them, by publication pursuant to board authorization entered on January 13th. Exhibit 13, again on file, is a affidavit demonstrating publication. Although SM has had conversations with some of the potential heirs and successors of the named estates, as outlined in Mr. Dean's declaration, none have leased or otherwise committed their interest to the Austin Anchor 2560 unit. Accordingly, the full list of names identified in the list of estates remains to be pooled here today.
I ask something right there.
Of course.
So if you find a state, obviously have numerous descendants.
Potentially.
What if 1 or 2 of those decide, you locate them, want to join? Do you still force pull the whole estate just to cover it?
Well, so yes and no. On what you would see is the estate of John Rogers is being pooled. If John Rogers, when he died, had 4 heirs, his 4 children, and it was clear and unequivocal, and 3 of them had leased, and 1 of them just hadn't responded, the pooling request would still request the pooling of the estate of John Rogers. However, the company would recognize the leases by the 3 heirs and would only have essentially 25% of John Rogers' interest subject to compulsory pooling. if that makes sense.
Well, if you have many, I mean, you can have,
Then it's 2% is subject to compulsory pooling instead of 25%. They will recognize, and Mr. Dean can talk about this or confirm this in his testimony, but as oil companies go out, they try and lease anyone who owns an interest because that's the way they protect themselves and give themselves business. It's by going out and getting rights to develop. Those rights to develop are through leases. So the only way they have the right to go out and drill is by finding people to lease their minerals. So they put a lot of effort into finding unlocatable and unknown heirs and decedents of estates because it gives them the rights to drill and develop and produce.
there's still gonna be a mix. You can have the state and you can have those that chose to. In this case, no one chose to, right?
And what we have also, I think the more common example is we know that the estate of John Rogers only has 3 heirs. We don't have a conclusive order from a court. We're pretty clear there's only 3 heirs, and we have leases from all 3 of those heirs. But because there's not a conclusive order, we still need to pool the estate of John Rogers because we might be wrong. So most of the time, all of the interests under the estate are leased and treated as leased, but because of a technical defect, the estate has to be pooled just to be safe. If that makes sense.
Yeah, so the owner can participate or be leased, be part of it. The estate's still there.
The estate is still the technical mineral owner of
Who gets paid?
Once the estate is distributed, then whoever's entitled to it based on the terms of their leases. So what happens is, the companies will say, I'm calling this right now in you as the heir of Mr. John Rogers, the estate of John Rogers, but you're not going to get paid on your interests until you have a court order distributing these estates.
So that's motivation for them to move forward to get that settled.
It's motivation for them, but it also is protection for the operators. So it's kind of both. It's saying, we don't want to pay the wrong party. You don't want the wrong party to be paid. So, once you prove to us that this is distributed and you're an owner, we'll send you the money.
All right.
So just to sum up, the parties listed in the request to be pooled and the estates listed, they remain to be pooled here today. Also, as reflected on Exhibit 8 and discussed in Mr. Dean's declaration, the acreage weighted average royalty to be applied in this cause is 16.917434%. And with that, I'll jump into Mr. Dean's testimony. Mr. Dean, state your name and business address for the record, if you would.
Levi Dean, business address is 1700 Lincoln Street, Suite 3200, Denver, Colorado, 80203.
Okay. And what is your position and your job responsibilities?
I'm a senior landman over this unit, so responsible for balloting, leasing, negotiating JOAs.
Okay. Are you aware of what's been filed as Exhibit 12? Let me make sure that's the correct number. Exhibit 11, the declaration of Levi Dean in this cause?
Yes, I am.
Okay. You've read the allegations, are familiar with what it says?
Yes, I am.
And did you sign it or have your counsel sign it on your behalf?
Yes.
Does that declaration testimony represent your full and complete testimony here today?
Yes, it does.
Did you hear the discussion? Mr. Rogers just asked me a question during kind of my introduction, and I did a terrible job being a land witness, but will you kind of talk through, how SM, or how you, I should say, looks at, the pooling of estates and what you do and how you treat partial leasing of estates, et cetera?
Yeah, absolutely. And for the record, I think you did a great job explaining it. But typically, we have all the parties pooled or already leased from a deceased owner. But there is the possibility that we don't have all those parties identified. So that's why we do keep it in the estate and then keep it in title suspense until that estate gets distributed to the proper heirs.
And that protects the mineral owners from essentially getting in a fight with someone else if they come forward down the road and say, I own it, and you've already paid the wrong party. If you paid now, it would create that kind of hidden problem for mineral owners once they start to distribute estates.
That's correct. And also with the minerals being real property, I mean, you need an actual distribution out of the estate.
I appreciate that. Last question before I let you go and have the division and hearing examiner ask you questions. Do you believe the JOA that the hearing examiner is considering the terms are fair, just, and reasonable and customary in the basin?
Yes, I do.
Okay. I have no further questions for Mr. Dean, subject to hearing examiner or division questioning.
Division?
Yeah, I have a couple of questions, Mr. Dean. Based on your declaration,
I can pull up anything if you need to.
Sure. So we have parties in here that we've seen quite regularly. But Wells Fargo, you indicated that they reached out to you. Did you do anything different to actually get them to respond this time? I'm just curious what happened there, because we've seen them many times and we got no response.
Sure. No, I think the only difference in this situation is SM has worked with their counsel in the past. So it was actually counsel for Wells Fargo that reached out. And I don't know if there's a previous relationship there, but it came through our legal department before it came to me. So that's really the only difference in this situation.
Okay, thank you. So Exhibit 14 filed, that's the returns of service. There's not a lot in there. We're missing quite a few. Have you received any other returns of service since the filing of Exhibit 14?
I have not.
Okay.
We get all that
Yeah.
and file it as it comes in, but same.
It's light this time.
Yeah. What I will say, and maybe this is part of it, some of these parties do apply to the other units.
Okay.
And so one of the things we've seen is a lot of them coming back. So for example, the Austin Powers unit, 1280, that was filed in September. We've had a lot more time for those to come back. We're still waiting, I think, on one of those to come back even, but we've seen several of them come back undeliverable. Those same parties with same addresses were included in these later filings, and we've now discovered, so we anticipate most of them to come back undeliverable that haven't been returned yet.
Okay.
To the extent that, and even we will continue to update the record with additional returns of service.
Okay. So along that lines, we do have some, what do they indicate on there? Does it say undeliverable or address unknown?
Unable to forward.
Yeah, there's a couple on there. However, the REA indicates these parties did receive a JOA, a notice of opportunity to participate in a JOA and so forth back in 2024. Since those notices were sent out in 2024 to participate in the well, up until the notice went out for the compulsory pooling, has any additional action been taken on your part to update those addresses or an update of a title opinion or so forth?
There hasn't been. We got a pretty recent title opinion that was in the testimony. I think don't remember the effective date of it, but we have not taken any further action to further locate any of those parties.
Okay, so I just assume that at the time of, well, I'll ask you. So, do you have any explanation as to why they would have received the notice to participate, but they're now undeliverable as to the notice of the compulsory pooling?
I think in this case, it might be a method of delivery. I think when we send notice, I believe it goes USPS certified. Typically when we send out well proposals, we do it through FedEx. So I don't know if there's oftentimes we'll only get a notification that something was delivered. And then sometimes if it ever gets returned, we'll get it a month later, 6 months later, a year later. And I don't know, it's tough to know kind of what the situation is. We only get the delivery confirmation from FedEx, whereas if there's no one there to sign for the USPS certified mail, then typically I think it comes back a lot faster, if it does come.
All right.
One of the things anecdotally, not necessarily, is what I've seen over the years is oftentimes we'll mail 2 or 3 times, in an area to the same person, and the third time we'll get a response, does not live here, hasn't lived here for years. So I think part of it is people accept things don't do anything about it until it gets to a point where it annoys them. And so I think sometimes it's a function of, we think we sent it to them, this is their address, someone received it, and it's not till later that we find out.
Sure. So just one last question, Mr. Dean, just for the record. So to the best of your knowledge, were all the parties that are being asked to be compulsory pulled today, were they all mailed a notice of this proceeding based on their address of record?
Yes, that's correct.
All right, thank you very much. No further questions from the division.
Okay. Back to this thought of estates and deceased people. Is it common out there? I assume it is, because it looks like this can go on generations where nothing is done.
Very common. Mr. Dean, I bet you could probably talk about that.
Yes, it's very common.
Okay, and that makes it even more difficult because it grows exponentially, the number of people needing to be notified.
That's right. Well, and where they've gone, right? Typically, there are a couple groups of people kind of raised out in the basin. There are those that stay in their family states, and they're fairly easy to locate. And there are those who, kids move out, and those can be spread all over the country, some internationally even. So we end up with typically bigger families in Utah, typically more children, and then a couple generations removed and scattered around. So it can be really difficult to track down the current owners.
Okay. Now, I've wrapped my brain over this, and I've tried to figure it out. But what is a DUBWDSU?
It is a creation of board council from 6 or 7 years ago. Short answer is it's a section line well. Board council at the time didn't believe section line well was the appropriate name for it because it may not always be located on a section. And so the idea was, this is a well that's permitted between the boundaries of two units. So it's a drilling unit boundary well.
Oh.
Drilling and spacing unit.
I got the last part, but I could not figure out the first. Okay.
So that's the.
Did you know?
Part of the problem is there's no real accepted nomenclature in the rules, and all we have is kind of our current and ever evolving language. And it's
okay.
You can just call them boundary wells. That's
boundary wells make sense to me.
That's how most people just refer to them.
Okay, I just saw that and I go, I've never seen that. So
my hope is that whoever it is that's counsel for DNR right now will just clarify some simpler way that we'd like to identify all of these going forward. Because I agree, it's a silly. It's the best we have right now.
Okay.
But some clarity would make a lot of sense.
To insulate and protect council, I think we need to keep calling it the WDSU.
WDSU.
It makes you sound really smart.
It makes everyone else annoyed, but yes, I'm happy to do it.
You may I.
Fair question.
Okay, thank you. I don't have any more questions for Mr. Dean.
Okay. Mr. Peterson, have we even gotten to you yet? It feels like we've been here forever, but you ready to bring this one home?
I'm ready.
Okay. Will you please state your name and business address for the record?
Yes, Brad Peterson, 1700 Lincoln Street, Suite 3200, Denver, Colorado, 80203.
Okay. And your job title and responsibilities generally?
Yeah, I'm the Utah Asset Manager for SM, and my job is to really lead development planning, optimization, and execution.
Okay. I'm going to ask you the same questions I asked Levi, but with a slight difference, right? Do you recognize what's been filed as Exhibit 12 in this cause, the declaration of Brad Peterson?
Yes.
You've read and are familiar with all the allegations that it contains?
Yes.
Did you sign it or have your counsel sign it on your behalf?
Yes.
Any clarifications or corrections that you need to make to that declaration?
None.
Okay. In your expert opinion, the actual costs of the wells in this unit are fair, reasonable, and are within a reasonable variance of the estimated costs?
Yes.
And do you believe a 300% risk compensation award is justified based on the risks in this drilling?
Yes.
With that, I have nothing further for Mr. Peterson, subject to cross-examination.
Division?
Yeah, so we've reviewed Mr. Pearson's declaration. We don't have any specific questions. I would just ask though, and maybe it was in there and I missed it, but when you were drilling these wells, I assume because the AFE cost and the actual cost were pretty close. Did you encounter any specific issues in the drilling of these wells?
No, they were roughly on average about 300,000 higher. But no, nothing that was a big difference. I would say some of the previous ones we had a bigger discrepancy in AFE versus actual due to things that came up, but these are just overspent a little bit, but pretty close.
Okay, great. Yeah, no further questions from the commission. Thank you.
Okay, thank you. Mr. Peterson, Mr. Mail has already asked you about your declaration. That's your testimony. At this time, I'd just like to ask if you have anything to add to that.
No, I don't have anything else today.
Okay. Again, we went over this in the last matter. Just the risk will, I understand what you're going on there, but I think in the future, if we have a risk spelled out and how you came to that, that would be helpful.
I'm happy to do that.
Okay. Do you have any questions for this witness? Okay, we'll proceed on then.
At this time, it's probably appropriate to move for admission. So I will formally move for admission of exhibits 1 through 14, and this includes the 2 declarations submitted as testimony.
Division?
Yeah, no objection.
Okay, so admitted.
Thank you. And in close, I'll simply say I believe we've met the statutory and regulatory requirements for pooling, and the pooling is warranted in this cause. I thank everyone for your time and attention and ask you to approve the request as pledged.
All right, thank you. The division has filed a responsive notice of non-opposition to the request for agency action dated February 10th, 2026. My understanding, the division has no objection of this request for agency action. Is there anything else you would like to ask at this time?
No further questions.
Okay. And anything you'd like to present?
I can just do a closing statement if you'd like that.
Okay, we'll do that. Okay, we'll take closing statement now, beginning with Mr. Mail, then go to you, Mr. Haynes.
I already gave my close. I think we've met our requirements, and I appreciate the time and attention. So I'll let Mr. Haynes take his.
Yeah, additionally, the division, we reviewed the request for agency action, the exhibits, the declarations that were filed, and based on the testimony today, the division has no objection to the granting of this request.
Okay, thank you. Okay. Okay, we admitted the exhibits, correct?
We have.
Okay, so having reviewed the request for agency action, all exhibits, and having considered the evidence presented today, I find that SM Energy has provided sufficient notice of opportunity to the non-consenting compulsory pooled owners and those owners identified in the request for agency action, and did not timely elect to participate in the wells and therefore should be deemed non-consenting parties. I find that the 100% for surface equipment and the 300% for drilling costs as a non-consent penalty is fair and justified given the economic and geological conditions present with these wells, and find that it would be appropriate to impose the requested non-consent penalty. I find that SM Energy has met its burden of proof to show they are entitled to forced pulling of the named interest and other relief requested in the request for agency action. Mr. Mayo, will you prepare the order?
I'm happy to, and I'll try and get that circulated this afternoon if possible.
Any other comments before we close? If there are no comments, we'll adjourn this proceeding. I appreciate your time taking this matter.
Thank you. Levi, Mr. Peterson, Mr. Dean, you guys are done for the day. Thank you for your time. Appreciate it.
Okay, thank you.
Thanks.
What? Okay.
I'm feeling Brett. If you'll check in from there, I'll run out here and text them and make sure they're
Okay.
Matt, do we have one more proceeding?
Or we're going to take a short break, and we'll back.
Okay, thank you.
Good morning. My name is John Rogers, and I'm an environmental manager of the Utah Division of Oil, Gas, and Mining. I've been appointed by the Board of Oil, Gas, and Mining as a hearing examiner in this proceeding. Today is Wednesday, February 18th, 2026, and this is the time and place for the hearing examiner proceeding for docket number 2026-012, cause number 132-84. In the matter of request for agency action of 4 Point Resources, LLC, for an order pulling interests, including the compulsory pulling of interests of certain non-consenting owners in the Aldrin 13-7-4-4-13-14-7H well identified herein in the drilling unit established for the production of oil, gas, and associated hydrocarbons from the Lower Green River-Wasatch Formation, comprised of all of Section 13 and 14, Township 4 South, Range 4 West, U.S.M, Duchesne County, Utah. We are holding this hearing with the anchor position at Department of Natural Resources in the building in Salt Lake City, Utah. We also be hearing testimonies and presentations in person and virtually, and the proceedings will be broadcast on the internet. Before we begin, are there any members of the public or respondents present that wish to comment on these proceedings?
No members of the public online, sir.
Okay, thank you. Let the record show there's no public respondents present. We'll take appearance in council at this time. U.S.M.
Thank you. Sorry about that, Mr. Rogers. Mitch Mayo of Lear & Lear PLLC, not on behalf of SM Energy, but on behalf of 4 Point Resources in this matter.
Now, did I mess up there? It's 4 Point.
This is 4 Point.
Yeah, did I say SM?
You did. That's okay.
Oh, I said when I referred to you. Okay.
Yeah, when you refer to me, that's all right. Yeah.
Well,
you read the right caption. We're in the right matter. I just messed you up by switching them around.
Sorry about that. Division.
Assistant Attorney General Andrew Haynes on behalf of the Division of Oil, Gas, and Mining.
Assistant Attorney General Gary White, and I represent the hearing examiner today.
Okay, thank you. I have received declarations for this matter for Mr. Philip Musial. Is that correct?
Yes, sir, Musial.
Okay. Landman for 4 Point Energy and will testify to issues of petroleum land management. And Mr. Brett Kovic, a senior reservoir engineer for 4 Point Energy. He'll testify as a petroleum reservoir engineer. I reviewed both of their declarations before this hearing. Mr. Mayo, I understand that Mr. Musial has not testified before this board before. Could we have him review his education and work experience at this time?
That's great. I can do it now or during his testimony, whatever you prefer.
So just take care of it now.
Okay. Mr. Musial, would you please state your name so we all know how to say it and your business address for the record?
Yes, it is Phil Musial, and our address is 100 St. Paul Street, Suite 400. That's Denver, Colorado 80206.
Okay, thank you. Now, I intend to put your testimony here as both fact and expert testimony. But in order to offer your expert testimony, we need to qualify you as an expert. Your resume has been submitted, and everyone here's had a chance to look at it. But if you would please walk us all through kind of what your experience, your education, your resume say about your expertise in petroleum land management.
Yeah, absolutely. So for undergraduate, went to University of North Carolina at Chapel Hill, and my BA was in English literature. From there, went to Wake Forest Law School and moved out to Colorado shortly after finishing law school to take the bar exam out here. I ended up getting a position at Noble Energy at that time as a division order analyst and worked at Noble for a couple years, got moved up to an analyst 2, and at that point had passed the bar and was kind of interested in seeing more of the legal side of things. So I went to a title firm in town and did some title work there for about 1.5 years, and realized that being a title attorney is a lot of, sitting in a room by yourself, reading things out of a box. So I kind of wanted to get more involved with the other side of things again. Ended up going to 4 Point. That was about 10 years ago now. Started back there as a land DO analyst again. And it's really, private equity, smaller company at the time. We were basically everyone doing everything. So worked through a lot of contracts and leasing and JOAs, and jumped on when we got this new asset, the diligence for the purchase and reviewing the units and working on workovers and reviewing JOAs for those and making sure that we're following all the terms and all the different situations. And back in September, had my title updated to landman. I think that I've been kind of working through the same types of things for a long time, but that's my basic background of getting me to the point where I'm at.
Okay, so from 2016 forward, you've been with 4Point the last decade, and as part of private equity backed, venture capital backed, however you guys classify it. You're not a publicly traded company, and you're not staffed like a publicly traded company. Is that fair?
Yeah, I think that's fair. I think that the general attitude here is that everybody does everything and you just do what needs to be done.
Okay. Would you say that your resume is, and I'm going to be just blunt, right? You haven't been a landman as a title for very long. Is it fair to say that maybe that title is behind, that maybe you've been kind of functioning as a landman of sorts for longer than that? And if so, can you kind of talk about how much time you think that is?
Absolutely. I would say that from 2020 onward, when we had kind of gotten smaller as a company, that everyone kind of started picking up additional tasks and doing things that might not really fit under their job title. And then when we were reviewing all of the diligence for this asset before we purchased, I was brought in to help with the other landmen in that review. And we were all assigned units to work through, and just a number of things that on the legal side, obviously you're working with these documents all the time, having that kind of background with contracts. And then on the division order side, we have a lot of workovers where we're having to review JOAs and determine the terms and make sure that we're following everything and doing it correctly. So I do think that is the case, that I'd been kind of doing the nuts and bolts everyday work for a while before the title was eventually updated.
Okay. Would you say that for a while, that time you've had with 4Point and where you've been doing what you think is landman responsibilities at the company, do you believe you've had enough exposure or sufficient exposure to JOAs during that time, basin, Uinta Basin JOAs during that time, to have kind of formed an expertise on the types of provisions you see and don't see and should and shouldn't see in those types of JOAs?
Yes, sir, I do. And I think a big part of that was heading up the workover project when we first took over the asset. And part of that is, reviewing the relevant JOAs for everything. But yes, I would agree that is the case.
Okay. Without getting too much down a path that I'm not sure, I'm going to turn you over now to the division and hearing examiner to ask questions as they see fit.
Sure, thanks for that great summary. Thanks for those questions. Just a couple follow-ups. Do you think you could quantify in your time in the roles that you've had, how many JOAs you've probably reviewed? It doesn't have to be specific to the Uinta Basin, just in general.
No, I would say it's definitely in the hundreds. I don't know if I've cracked 1,000, but certainly that a good deal of them in my time.
And are you do you have any certifications as a landman?
No, I just am licensed to practice law in Colorado. I do not have the landman certification.
Which I'm biased, but I think that's the primary landman certification.
Sure. Yeah, the division has no further questions.
Do you have any questions for me? Okay. So we will now we'll accept Mr. Musial as accepted as expert witness in petroleum land management at this time. Okay. Oh, yeah, the issue. I thought he did already.
I was just asking questions, but based on his testimony, as to this matter, we're fine with him.
Mr. Haynes and I discussed prior to this that, Mr. Mr. Musial's resume is a little thinner than most of the petroleum land management that we have. And so we tried to ask questions and get some level of comfort, and hopefully the division's at that place. But
Okay,
Perfect, yeah.
okay, we'll accept him as an expert witness.
thank you.
Okay. Mr. Mayor, I also understand that Mr. Kovac has not testified before this board before. Is that correct?
That is incorrect. Mr. Kovac's been here a couple of times.
Oh, okay.
He was, I think, recognized as an expert last month, right? In January of 2027. Mr. Kovac, is that right?
Yep, that's correct. I think we've been monthly for the last 4 or 5 months, maybe 6 months, maybe.
Oh, I must have missed that.
That's right. January 2026. I misspoke. It was in cause 130-47 for the record.
Okay. Division, do you have any questions or for him?
No, we're good. Thank you.
You accept him as expert witness?
Yeah.
We will accept Mr. Kovac as an expert in petroleum and reservoir engineering. Okay. Can we swear the witnesses in at this time?
That seems appropriate to me.
Okay. All right. Will you please raise your right hand? Do you solemnly swear that the testimony you give in this matter shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yeah, I do.
For the record, the witnesses have affirmed yes to the previous statement. We'll now proceed to Mr. Mayo for his presentation.
Thank you. You know, Mr. Hearing Examiner, you hit on a lot of the things I was going to say in my introduction, and honestly, in the interest of time, it probably makes sense for everyone if I kind of breeze through the rest of it. The board and the hearing examiner have jurisdiction over this matter pursuant to Utah Code 40-6-6.5 and the governing regulations. A copy of the request and of the notice of opportunity to participate was sent by certified mail to the known parties to be compulsory pooled and was sent by regular mail to all other production interest owners within the drilling unit, all at their last known addresses of record. In addition, the request was mailed to all relevant federal, state, and tribal agencies as applicable due to mineral ownership within the unit. Notice of the filing of the request and the opportunity to participate and of this hearing was also published pursuant to board order in the Uinta Basin Standard on both January 21st and January 28th of 2026. Exhibit 21 on file is a true and correct copy of this affidavit of publication. On February 10th, the division filed its notice of non-opposition and essentially reserved judgment pending the full decision here today, or the full presentation here today. There were no objections or responses timely filed, and there are none pending here today of which I'm aware. In sum, this cause involves the compulsory pooling of a 2-mile, 1,280-acre drilling unit established for Lower Green River-Wasatch formation production and comprised of sections 13 and 14 in Township 4 South, 4 West in Duchesne County. The drilling unit was established by board order entered in April of 2024 in cause 130-27. 4 Point is the majority interest owner as shown in Exhibit 5 and is confirmed in Mr. Musial's declaration. Pursuant to the current order, and a true and correct copy of that is on file as Exhibit 2. 4 Point's predecessor in interest, Ovintiv USA Inc., spud the Aldrin well on October 10th, and it was completed with the date of first production on March 24th of 2025. At the time the request was filed, there were no new wells producing from the subject unit, but there were 2 wells that were producing from portions of the lands that are included in the subject unit. The Phillip well and the Fee well. As discussed in the request for agency action, the current order, the 130-27 order, expressly accepts out the Phillip and the Fee wells from conversion in this cause. And because there is no conversion at issue, there is no waiver of recoupment needed to be addressed in this matter. Several owners of undivided oil and gas interests in the subject unit and subject well have refused or failed to lease or otherwise agree to pay their proportionate share of the costs, including those names that appear on page 2 of the request to be compulsorily pooled. In addition, there are several deceased parties to be pooled. These are also identified on page 2 of the request for agency action. Although 4 Point believes it has leased all of the successors of said estates and voluntarily pooled their interests, we can't be certain without conclusive distribution, so the estates need to be pooled nonetheless, out of an abundance of caution. Pursuant to board order entered on January 13th, 2026 in this cause, the notice of opportunity to participate and of this hearing was provided to the estates and anyone claiming by, through, or under them by publication. And I'd like to remind everyone, Exhibit 21 on file is a true and correct copy of the affidavit of publication. There's a couple corrections that I want to make at this time to the request and to the declarations. As noted in Mr. Musil's declaration filed on February 10th, the estate of Pearl F. Moon was named to be pooled. However, that estate has since been removed as 4 Point has been provided with sufficient evidence that the interests of Pearl Moon have been voluntarily committed to the subject unit.
So let me add there. So in our previous discussion, you feel comfortable that everything, so the Pearl Moon estate is complete? No?
That's right. That's right. So typically it happens in a couple of ways. One is a party will reach out and say, I've secured a probate order. Here is the distribution. And then we'll look at all of the heirs of that and confirm that all of them have leased. And once we know that, we know who the heirs are and they're committed. We can remove the estate. In this instance, it's slightly different. Pearl F. Moon is a family member / relative of board member Gordon Moon. And he reached out and updated 4 Point on the leasing status, gave them the information they needed. And essentially through that discussion, 4 Point understood that that interest now is voluntarily committed. So it wasn't so much a proof of distribution as it was an explanation of distribution and of title.
So your preferred method is getting that probate?
Well, in this case, it wasn't necessary.
Yeah, but in most cases, you would say that's
the only thing that a company will essentially let the matter go is if they have a court order or some other binding distribution, because then it satisfies the marketable title concerns. That removal of the estate of Pearl Moon was noted in the filed February 10th. Yesterday, I filed an updated declaration. I assume you all received a copy of that. The only change to the declaration related to the removal of another party, Tracy Lee Markham Sherrill, has since reached out and participated with her interest. And so in order to give everyone a heads up, we filed the declaration yesterday. And if approved, the order that issues will note those two parties' removals, the estate of Pearl Moon and the interest of Tracy Lee Markham Sherrill. Aside from those two parties, the parties identified in the request for agency action remain to be pooled. Also, as reflected in Exhibit 15 on file and as discussed in paragraph 32 of Mr. Musil's declaration and updated declaration, the acreage-rated fee landowner's royalty in the subject well is 18.476317%. Notice was provided to all interest owners in the subject unit as outlined in paragraph 28 of Mr. Musil's declaration and as memorialized in the certificate of service on file on January 15th, 2026 in this cause. And without getting into too much further, I'll just move into discussing the testimony of Mr. Musil. Phil, can you please state your name and business address? You've already stated for the record, but if you wouldn't mind doing it again as part of your testimony.
Absolutely. Phil Musil, and 4 Point's address is 100 St. Paul Street, Suite 400. That's Denver, Colorado, 80206.
Okay. And as you discussed earlier, you're a landman for 4 Point with responsibilities in the Uinta Basin, including the unit that we're discussing here today. Is that correct?
Yes, sir.
Okay. And you just qualified as an expert in petroleum land management for purposes of this cause. So I'm going to ask you, simply to clarify, qualify your declarations and open yourself up for questions. Do you recognize what's been filed as Exhibit 19, the declaration of Phil Musil in this cause?
Yes, sir.
Okay. Are you familiar with allegations that are addressed in that declaration?
Yes.
And did you sign or have your counsel sign that declaration on your behalf?
Yes.
Are you also aware of the updated declaration that was filed yesterday in this cause?
Yes.
And can you briefly just hit on what it is that was necessitated that filing?
It was just the election being returned. It had ended up on one of the other landmen's desks, and they provided it to me, and I checked with all of them to make sure there weren't any others. I think it was just a mailroom mix-up.
Okay. So an election you received sometime during this request for agency action being open, but you just received it yesterday and we got it filed.
Correct.
The updated declaration, was that signed by you or by your counsel on your behalf?
Yes.
And is the declaration testimony outlined in the updated declaration filed yesterday, does that constitute your full and complete testimony here today?
Yes.
Anything you'd like to add or modify based on the discussions we've had?
I don't believe so.
Okay. With that, I don't have any further questions pending division questioning.
Division?
Yeah, based on the declaration, the division has no further question for Mr. Major.
I got a few questions for the declarations we received here. I got one I call the original, one is the new I got yesterday. Right?
That's right.
And I understand where Tracy Lee Markham Cheryl, that's straightforward. She was removed, but sometimes it might be helpful when you put removed to say right there in the document, either cross out for who was removed.
In which document?
Like right here, it says removed, just referring to there.
Oh, yeah.
It's sort of a guessing game. I mean, they got footnotes you can go through. That'd be helpful, So what's the change between the old document and the new one?
Isn't it marked removed? I'm looking at that and seeing.
Well, it says removed, but if you don't know who it is.
Oh, okay.
Okay, so I'm looking here.
It's hard to identify their name and
it says
identify
Tracy Lee
their-
Markham, and then just removed. I mean, I could, I figured it out, but that'd be helpful. Then you're not guessing.
Well, one thing we try and do, and maybe it'll help, is at the very end of the declaration, we try and do a paragraph discussing it. So paragraph 31 in this declaration kind of identifies the names that were removed and discusses the removal in more detail.
And I found that, but
It's just hard to do it. It's kind of like that short sighting we discussed earlier.
Okay. Putting
Putting all the information in every sentence is tough.
And my next question is Pearl Moon. Okay, here's the original. It's marked removed, and in the new document, it's marked removed. Why did we include her in the original document removed? If she's removed, why didn't you just take her out completely?
So you're talking about removing her from the declaration.
Well, here's the original.
Yep. So I've got them here.
The next one.
That's right. So the declaration is Mr. Musil's sworn witness statement here at the hearing. And February 10th, his sworn statement was that Pearl Moon was being removed. Yesterday, his sworn statement is that Pearl Moon is being removed. So there's a couple options I could take yesterday when I found out. I could file a simple additional declaration. And all it would say was, my name's Phil Musil, I'm a landman, and I've removed the estate of Tracy Lee Markham Cheryl. But then you would have to look at two declarations at the same time. My hope was that by preparing an updated declaration and identifying specifically what had changed, all you need to do is look at the updated declaration. And it has all the information that was contained in the original declaration.
So the original, she was not removed. I mean, she was removed.
So you asked about Pearl Moon.
Yeah.
The reason we filed the updated was to address Tracy Lee Markham Cheryl. But the reason we included Pearl Moon in the updated was because, in my experience, it's better and easier for the people evaluating it to look at one document rather than have to go through two or three.
But if she was, I mean, I guess I'm beating this down, but if she was removed back then in the original.
She's removed from the request, but she's not removed from the declaration. The declaration is his testimony.
Okay.
So we'd either need to discuss both of his sets of declarations at the hearing today, or we need to have the removal included in both sets so that we can address just one, if that makes sense.
Okay. Okay, another question I have is, this originally was spaced on vertical 1280s.
That's right.
And the Phillip well is a stand-up well from section 13 south to section 24.
That sounds right.
Okay. So how is that conversion going to take place? Now you're going to go lay downs. What's going to happen to that Phillips well?
Well, so the one thing is, you know, a couple things. When the stand-up unit, the Phillip well unit, and witnesses feel free to chime in if you have, you know, a better answer. The Phillip well, when it was established, that unit as a stand-up, that order actually said in it, we're not entirely sure which way this unit should be oriented.
And I read that.
So they established it as a stand-up, and subsequent to getting drilling results, Ovintiv at the time decided we don't like it as a stand-up. We think it should be a laydown. And so when they went in to respace the unit as laydowns, counsel, Mr. McDonald, worked with the board in getting the order, but the order just lays out exactly what happens. It says the Phillip well is newly drilled. It goes this way. Because it's newly drilled and because of the setbacks, we don't think conversion makes sense. So the Phillip well is going to remain payable on that stand-up allocation, and it won't convert.
So someone that has minerals in 13 is going to get from both. They're going to get from the horizontal.
The horizontal, that's right. I see Phil nodding his head. Maybe you should hop in and give him a little comfort on how this is going to be paid.
Yeah, no, you've got it, Mitch. We are not converting the Phillip well. That was already drilled and producing when we took over operations. So we are, you know, took Ovintiv's revenue deck, and we're still paying the same people the same way they were being paid on the Phillip. And then the Aldrin is being spaced for 13 and 14. So yes, to answer your question, if somebody owned in 13, they would be in both the Phillip and the Aldrin well, but we're not converting the Phillip to be a lay down rather than a stand up.
So looking at it from my point of view, you're being very generous.
I mean, I don't know that oil companies get that slur thrown at them very often, but I think we'll all accept it.
Well, I mean,
the truth of the matter is, you know, it's I think less about generosity and more about trying our hardest to be fair now. Right? Ovintiv back in the day, before these two gentlemen even were in the picture, Ovintiv came in and said, we don't think it's fair to the people in the Phillip well if we suddenly convert it, because this just happened. They just drilled it. It's not their fault that it's as a stand-up and should be a laydown. And so I think at every step, operators and their counsel, we try our hardest to make sure that it's just as equitable as possible.
So as you move south and drill a horizontal well in 23 and 24, you do the exact same thing?
Mr. Musel, do you guys operate 23 and 24, and do you plan on drilling, or have you drilled?
So I believe that this was part of a trade that Ovintiv made with U.S.M prior to us taking over operations that is referred to as the lunar landing trade. There's some wells that are named after astronauts. And I think that with the trade, they might have that acreage there to operate. I'll have to double check the land records. It's not currently on our schedule to drill 23 and 24.
Okay. So did you understand?
Yeah.
Okay.
So as you move east,
Mr. Rogers.
So Peter Payne through the division, the U.S.M has wells planned in 23 and 24 currently, and they're being permitted, or they are approved permits. So they're definitely.
So they'll run into the same problem.
But the good thing about it is that Phillip well was the spacing order that set these units up. The Phillip well was accepted out from conversion. If U.S.M goes in and spaces them anew, they may not be subject to conversion at all. Right? SM spacing orders aren't conversion orders, they're overlapping. So that'll be determined based on the specifics of that.
Okay.
This is one of the first ones we saw that was the drilled stand-ups and then converted to laydowns after the results of the stand-ups came in.
And there was a fair amount of discussion, if I remember, during the order, like during the process for getting that order, because it was
how that works and how they're gonna pay out owners.
Okay, as you move east then, I assume you're gonna do 1280 laydowns. I mean, I ain't sure it's their land to the east. Do you know what I'm talking about? Sections.
I believe that directly east of the Aldrin unit is the Armstrong unit, and that was respaced as a 15K already. And I believe that the pooling for that was done by 4 already as well.
Okay, that's all I have. Okay, Thank you. Sorry, just kind of was.
No, that's helpful. It's good to go through all that while we've got people here.
Okay, I have no more questions.
We're gonna finalize here. Mr. Kovac, will you please state your name and state the way you'd prefer we say it and your business address for the record?
Yeah, it's Brett Kovac. So yeah, Kovac, not Kovac. And address is 100 St. Paul, Suite 400 in Denver, Colorado.
Okay, thank you for that. Will you please remind everyone, you've been recognized as an expert for this cause, what your job title and your responsibilities generally are?
Yep, so senior reservoir engineer and, oversee this DSU at issue and a lot of other DSUs at issue as well.
Okay. Are you aware of what's been filed as Exhibit 20 in this cause? The
Yes.
declaration of Brett Kovac. Are you familiar with all the allegations that are outlined in the declaration?
Yes, I am.
Okay. And did you sign it or have your counsel sign it on your behalf?
Yes.
Okay. Does the declaration as filed as Exhibit 20, does that constitute or represent your full and accurate complete testimony here today?
Yes.
I don't believe I have much else for Mr. Kovac other than, can you briefly, give us that expert opinion on the costs? Do you think the costs were reasonable and necessarily and fairly incurred in this matter?
Yes, I do.
Okay. Do you believe they were within a reasonable variance of the AFE costs?
Yeah, given what the AFE was and kind of what our best estimate of the actual well costs were, that's a reasonable variance that, we see in a lot of the wells that we drill.
Okay. And that's one thing, most of these we have actual costs and estimated costs that are being compared. In this case, you have estimated costs by the AFE and you have estimated actual costs. Can you briefly hit on why that is in this instance? I assume part of it at least is the transition between the two companies, but is there more at play than that?
Yeah, I would say it's really the transition between the two companies. So there's a little bit of the kind of cost that we're, using kind of our best field estimates on, which historically our field estimates correlate really well with our actuals because the field estimates are kind of, looking at the daily tickets that we're getting from the vendors and are kind of summing those up over time. But I know that our team is currently also engaging with Oventive to try to get full actuals for this, but I believe that what we have here is very representative of the actual well costs.
Okay. So the options were either to wait indefinitely and hope that Oventive could provide a full verifiable set of actual costs and then pool this well if and when that happened, or to come up with basically a verifiable average that you could hang your hat on and say this is representative of the cost incurred.
Yeah, and in that note as well, at the bottom of the cost exhibit, it also kind of says that the completion and the production costs shown there are kind of representative of our actual spend at 4 Point. And so it's really kind of talking the drilling side where Oventive, drilled the well and then we took it over. So that's really where there's a little bit of a question. So it's really just that one line item. And, I think the field estimates are usually quite close on the drilling side.
Okay, that makes sense. That helps. Last question, risks. They're identified in Exhibit 18 and they're discussed in your declaration. Is it your expert opinion that the risks in this development justify the 300% risk compensation award?
Yes.
Okay. I don't have any further questions for Mr. Kovac, subject to cross-examination from the division and or hearing examiner.
Division?
Yeah, the division has no further questions for Mr. Kovac.
Okay, thank you. Thank you, Mr. White. Okay, thank you. Mr. Kovac, I've reviewed your declaration and you've testified that's your testimony. Do you have anything to add at this time concerning it?
No, I do not.
Okay. For note, the division has filed a response of notice of non-opposition to the request for agency action dated February 10th, 2026. Therefore, in my understanding, the division had no objection for the request for agency action, but reserves the right to update its response after hearing testimony. Is that accurate?
Yes, that's correct.
I'll turn the time over to the division if they have any presentation at this time.
Yeah, the division, based on the testimony we heard today and after review of the REA and the associated exhibits and declarations, the division has no objection to approving this request.
Okay. Would that be your closing statement?
Yeah.
Okay. We'll take closing from the petitioner at this time, Mr. Mayo.
Thank you. Before I do that, it's probably appropriate to move for admission of exhibits 1 through 22, which includes the declarations that we've discussed here today.
Okay. Division?
No objection.
Okay. Those exhibits be so accepted.
Okay. In sum, I'll just say I believe we've met the statutory and regulatory requirements necessary to pool this unit. Full notice was provided, and there are and were no objections or protests lodged. And so based on that, I thank the hearing examiner and everyone for your time and attention today and ask you to approve the request.
Okay, thank you. Okay. Having reviewed the request for agency action, all exhibits, and having heard testimony today and evidence, I find that 4 Point Energy has provided sufficient notice of opportunity to non-consenting compulsory pool owners and those owners identified in the request for agency action, and did not timely elect to participate in the well, and therefore should be determined non-consenting parties. I find a 300% penalty for drilling costs as non-consent is fair and justified given the economic and geologic conditions present. I find that 4 Point has met its burden of proof to show that they are entitled to forced pooling of the named interest and other relief requested in the request for agency action. Mr. Matt, will you prepare the order?
I'm happy to, and I'll try my best to get that circulated today or tomorrow.
Okay. I'll then present the findings and conclusions to the board next week at their board hearing. Any other comments before we close?
I think that's it.
Okay. I'd like to thank Matt for getting this all together and allowing these people to testify online. That's a big benefit to the company. And so at this time, we'll adjourn this proceeding.
Thanks, guys. Thank you.
Thank you, Carmen.
Thanks, everyone.
Thank you, Carmen.